Good morning. I'm Linda Ostovitz. I'm a principal attorney with Kerman in Maple Lawn, Maryland. And I welcome you this morning to this webinar on what you need to know regarding divorce. I've been practicing for about 35 years now, and my career has consisted of 10 years almost in the state's attorney's office. For over 25 years, I've been a business owner, both in my own private practice and then in a partnership I was in for a number of years. And in August of last year, I made the decision that it might be a good idea not to be an owner anymore, and how great it would be to have partners to practice in areas in addition to the areas in which I practice, which brought me to Kerman. So I've been doing seminars like this for probably the last 4 to 5 years. For the last 16 years of my practice, I've done exclusively divorce work. And what sort of motivated me to do this is the fact that oftentimes when I meet with somebody in my office for a consultation after about an hour, I have a pretty good idea about where things will end up. And I don't like waste, and divorce is a hard enough subject, and I hate to see people be embroiled in situations that have a much easier solution if maybe we can just get to people sooner, earlier in the process. So my goal in doing these seminars is to really heighten people's attention about what the options are in connection with ending a marriage, to kind of give you a little bit of an education about what the subject matters are, so that at the end of this webinar, hopefully at a minimum, you'll be in a position to at least start making some informed decisions that may include the fact that you need to sit down with an experienced family law attorney and get your bearings and get some ideas about what are good decisions for you in your matter. So basically, when we talk about what goes on in a divorce matter, everything falls into 3 big subjects. And those big subjects are children, property, and alimony. So when we talk about children, we have the categories that you see here, which is legal custody, physical custody, access, child support, and something called use and possession in the family home. So when we talk about legal custody, we're talking about who has the authority to make the major decisions affecting our children. Major decisions being health, education, religion, the big things. And under the category of legal custody, we have 2 options. One is sole legal custody, where one parent is vested with the authority to make the major decisions affecting the children. And the other option is joint legal custody, which is a scenario in which both parents make the major decisions affecting the children. Times have changed, and I think that there used to be the perception when you go into a courtroom that one parent or the other was going to walk out with custody. Nowadays, the court systems really have evolved. They recognize the contributions that can be made by both parents. And while it's not legally a presumption, certainly there is a perception when you walk into a courtroom anymore that the parents ought to be able to share legal custody, no matter what their differences. They ought to be able to put them aside for the purpose of making good decisions regarding their children on the big issues. The second category is physical custody, and that's about where does our child put his head on the pillow at night. So again, we have 2 scenarios. One is sole physical custody, where one parent primarily has the care and custody of the child. There's an access schedule for the other party. And we have a shared physical custody model. Shared physical custody meaning that the person with the lesser amount of time has at least 128 overnights a year. So that's shared physical. In either scenario, we need a schedule. We need children to be able to know where they're going. We need parents to know where their children are going to be. But those are the 2 custody components that we deal with. When we talk about access, generally speaking, we're going to have several different types of schedules. So we'll have a regular schedule, which is, what's our sort of regular course of access going to be during the school year. Sometimes we have a different schedule for the summer, because in the summer, clearly, we don't have the demands that we have during the school year. We don't have the schoolwork. We may or may not have the activities. Sometimes people provide for a different schedule in the summer. We also have holiday access, which typically is going to be some scenario where we address the major holidays. When do they begin? When do they end? And who has them? There's other access schedules that certainly can go into play throughout the course of a year. But the goal is to have some schedule that everyone's familiar with so everyone can plan. Child support is a function of the Maryland statute, and what that is a statute that tells us how to compute a number, which will be the number that is paid by one parent to the other to support a child. Child support is not taxable income to the recipient. It is not a tax deduction for the person who pays it. And it takes into account each party's monthly gross income, the cost of work-related daycare, and the portion of the health insurance premium that is attributable to our children. All those things go into a formula that spits out a result that is essentially a non-negotiable number. Child support is payable until 18 or 19 if our children are still in school generally. The last big category under children is something called use and possession of the family home. And what that's about is that while children's lives are changing because their parents are separating, the legislature has recognized that there may be circumstances under which it is in a child's best interest to be able to continue to live in his or her home. So use and possession is an incident of custody. Whichever parent might have use and possession of the family home is there, not for them, but is there so that the children can continue to live in their home. So use and possession, if it's awarded, can be granted for up to 3 years from the date of divorce. It's not automatic that it happens. If it happens, it's not automatically 3 years. And the court's going to look to a great extent at the school situation. If we have a scenario where our child's going to be graduating from elementary, make it easier, from high school in a year, it is unlikely that we're going to look at a 3-year period of use and possession. There's a number of other factors that a court considers in looking at use and possession, but the real meat of why we have it and why the court has the authority to order it is for the benefit of the children. The next big topic is property, and so what you need to know is that marital property is everything acquired during the marriage, no matter how it's titled. During the course of a divorce, there's a lot of questions that come up about a particular piece of property, how it was acquired, etc. And my mantra, if you will, is go back to this simple sentence. Marital property is everything acquired during the marriage, no matter how it's titled. So that can mean retirement, homes, cars, timeshares, vacation properties, property of every kind, property of every character, no matter how it's titled. Now, what is not marital property? Because there is an exception to that. What is not marital is anything that either of you had from prior to the marriage, and anything you can directly trace to that source. So if you think about it, if you had it before the marriage, it was not acquired during the marriage, so it's not marital. Another one is anything you receive by way of a gift from a third person. So if I give you $10,000 during the marriage or not during the marriage, and it's a gift to you, that's non-marital property, as is anything that's directly traceable to that gift. The next category is inheritance. So if either of you inherit money or property, that money, that property is not marital, nor is anything that's directly traceable to that inheritance. And then the last category is anything that is excluded by valid agreement, which is typically a prenuptial agreement. So we know marital property is everything acquired during the marriage. The exception is gift, inheritance, premarital, or excluded by a valid agreement. So what is the significance of property being marital? Well, the significance is that the court has the wherewithal to equitably divide marital property. Maryland is not a 50-50 state, although people oftentimes believe that it is. Part of the reason they believe that it is that equitable oftentimes turns into 50-50. But the court has a list of factors that it is to consider when determining a division of marital property, including but not limited to the duration of the marriage, what contributions each party made to the well-being of the family, sources of money to acquire property. So there's about 11 factors that a court considers. But generally speaking, all things being equal and looking at a marriage of long duration, a lot of times marital does translate into 50-50. But again, we are an equitable division state. So the next big category that we have is alimony. And alimony is money that is paid by an economically independent spouse to an economically dependent spouse. And the purpose is to enable the recipient to become self-supporting. It is taxable income to the recipient, and it is a tax deduction for the person who pays it. So we have two kinds of alimony in Maryland. One is called rehabilitative, one is called indefinite. And rehabilitative alimony is that which is paid for some set amount of time to enable the recipient to become self-supporting. So if we think of an individual who, let's say, has a skill set, who's been out of the workforce for a number of years, who needs to acquire some training or certifications or schooling or something like that, that's a classic rehabilitative alimony type of a scenario. The second kind we have is called indefinite alimony. It's sometimes erroneously referred to as permanent alimony. But that is money that is paid even after we have a dependent spouse who has gone as far as he or she can go economically, and we still have an unconscionable disparity in the standard of living of the parties. So if we take somebody who, let's say, has been out of the workforce for a long time, at home raising children, running a household, we have a spouse who has been out working, who earns, $300,000 a year. Our economically dependent spouse may get some education, may be able to get into workplace, but reasonably can only make $30,000 or $40,000 a year. Clearly, in that situation, we have an unconscionable disparity in the standard of living. The court in that instance has the right to order what's called indefinite alimony. So there are a number of factors a court looks at when considering alimony. The ones that really bear the most weight in my experience are those that are economically driven, such as what is the ability of the person who's paying alimony to support himself as well as the person to whom he's paying alimony. But we also look at education, duration of the marriage, what led to the breakup of the marriage, what contributions each party has made to the well-being of the family. We also look at what property each party has, even if it's non-marital property. What are the assets that each party has? All these factors matter, but at the end of the day, again, in my experience, those that are the most weighty seem to be those that are the economic drivers in consideration of alimony. So people say from time to time that alimony is dead in the state of Maryland. It doesn't exist anymore. No judges order alimony anymore. That's not true. It is alive and well, and there are circumstances under which it is ordered. When we talked about child support earlier, I told you that for child support computation purposes, we look at each party's gross income, among other things. If an individual is receiving alimony, then that alimony is added to that parent's income for purposes of computing child support. If we have an individual who is paying alimony, then that alimony is subtracted from that parent's income for purposes of computing child support. So that's alimony. So those are basically the three big subject matters that almost every issue falls under when we're looking at a dissolution of the marriage. So let's talk about grounds for a minute. How do we actually dissolve a marriage? So in the state of Maryland, which has actually changed a lot in the last couple of years, we have certain grounds, and that means that in order to get divorced, there's something you have to establish. Again, that's changed dramatically in the last couple of years in the state of Maryland. But what we're left with in terms of grounds are as follows. That is that once the parties have lived separate and apart for a year, uninterrupted and without cohabitation, that's grounds for divorce on a one-year separation ground. We have something called desertion and constructive desertion. Each of those also require a one-year continuous period of separation. Desertion being the scenario where somebody abandons the marriage. Constructive desertion being where a party creates a scenario where the other one has to get out to preserve their health, safety, self-respect. Again, both of those require a one-year separation. We have adultery, which does not require a separation at all, and one can pursue a divorce on the grounds of adultery when one has evidence of adultery. I'm very frequently asked, what is evidence of adultery? And it's a combination of two things, and one is predisposition, and the other is opportunity to have sexual relations with a person who's not your spouse. So the classic example is, you see two cars pull up in front of a motel. People get out of the cars, they hug, they kiss, they hold hands, they go into a hotel room, and 3 hours later they come out. That is evidence of adultery, predisposition and opportunity. I am often asked, if someone admits it, is that sufficient? Well, historically the answer has been no. It appears that there has been some movement in the legislature, and again, it's been dramatic in the last couple of years, that might seem to indicate that our requirement that we corroborate grounds is at least lessening and maybe even disappearing. But that's evolving at this particular moment. We also have cruelty of treatment as the grounds for divorce, which also does not require a physical separation. Cruelty of treatment, and this is my definition, is an insidious course of conduct that guts an individual of his own sense of self. And cruelty of treatment is not really one particular act. As I say, it's an insidious course of conduct. They're not that easy necessarily to establish because people who've been subject to this kind of behavior more often than not suppress it, work around it, because they have to live in the household with this individual. But the things that I have seen in my practice that have constituted cruelty of treatment, again, in a course of conduct type of way, are things like no access to money. I'll give you money to go to the grocery store, but before you go, I have to see your list. When you come back, I need to compare what you bought to the list, and you need to account for the change. Bad-mouthing your spouse. Well, you don't want so-and-so to be on your team because he's stupid. He's not going to be able to help you. Isolating a spouse from family members and friends. That's a common one that we see. Constant criticism. Your hair doesn't look good. You're too fat. You didn't wash my clothes the way you want. This dinner is terrible. Why haven't you cleaned the house? You're not allowed to get the mail. You can't answer the telephone. Undermining your authority in front of children. So these are just some examples, and it's not usually just one thing. Like I say, it's a combination of things, an insidious course of conduct. But a divorce on the grounds of cruelty of treatment can be pursued even while you're under the same roof. So the really new things that are happening in the legislature is this grounds called mutual consent. So I guess it was 2 years ago, 3 years ago, we got the one-year separation irrespective of why. Last year we got mutual consent. And what that's about is that people can get a divorce. It appears without a one-year waiting period. It appears without being separate and apart, so long as they have a written agreement that resolves all issues between them and they have no minor children. So this is our newest grounds. What's in the legislature now, and frankly, I don't recall at this second whether it passed or not, was the ability to have a divorce by mutual agreement, even if you do have minor children, but again, so long as you have a written agreement that resolves all issues. So Maryland has evolved a lot in the last couple of years in terms of grounds for divorce, and it being easier instead of harder to get a divorce in the state of Maryland. It is still the case that no matter what our grounds are, There's the requirement that there be a hearing. Again, what that hearing is going to look like in light of this corroboration issue, I think remains to be seen. But Maryland is absolutely moving forward in terms of making a divorce easier to acquire. So I've made reference to agreement. I made reference to a court. So let's just talk about procedure a minute. So basically, there's two ways to get everything done and to address the issues that we've talked about this morning. One is hard and one is harder. You know, none of this is easy, and I recognize that it's not easy. Basically, there's two ways to do it. And one is you do it by way of an agreement, and the other is you do it by way of litigation. There's only two ways. So how do we reach an agreement on all these subject matters that we've talked? So some of the options are this. Some people have the wherewithal to actually talk to each other, sit down across the kitchen table, say, here's what we need to figure out. What are we going to do in terms of the schedule? How are we going to handle money? How are we going to handle property? Some people can do that. Most people find that to be a difficult situation, and maybe they need some help. So then we maybe talk about a mediator. A mediator is an individual who doesn't represent either party, who meets with both parties, and whose goal is to try to help them reach an agreement. I think mediation is a great thing. It can be very cost effective. It can be very efficient. I am a mediator. And so my caution, I guess, if you go to mediation, is about the selection that you make. So there are people out there who mediate who are not attorneys, and people out there who mediate who are not litigators. And I believe that if you're going to use a mediator in a case involving the dissolution of your marriage, you want a mediator who is a trial lawyer. That is somebody who is a litigator, who has gone to court, who has tried numerous family law cases. You want somebody who has had a lot of experience doing mediation. And the reason I say that is, when you hire a mediator, you want somebody who will be able to answer a question you might ask. What might a court do with this? You know, what are options? What are things that can happen in the court system? And if you're paying a mediator who can't answer those questions, maybe you're paying the wrong mediator. Mediator can't represent either one of you. A mediator can't give you legal advice. There's a wealth of information that a mediator can give you if she has the experience of having a lot of time in a courtroom and understanding how things work. Another manner by which people may reach an agreement is through counsel. So each party may hire his or her attorney. Those attorneys may communicate with each other. They may negotiate with each other. The other manner that I'm going to tell you about, but I will tell you personally I'm not in favor of, is called collaborative. Collaborative is the process by which each party, that party's attorney, sign an agreement that essentially says they're going to settle this case. So in theory, that sounds good. What happens in practice is that you end up hiring other people to do various little pieces of the case. So if we've got financial issues, you're hiring a financial neutral. If we've got issues with children, we may be hiring a coach or a counselor for the children. If the parties are having difficulty with dealing with this subject, we may hire coaches. And when I say we hire, you know who we is. It's you. So we're hiring a lot of other people to participate in this process, which I think may be great for the attorneys involved, but I'm not satisfied it's great for the people involved. If the circumstances are that we go through the process and we don't reach a resolution, then you must fire that attorney, hire somebody else, and then sort of start over again. So I will tell you I'm trained collaboratively. I philosophically always had a problem with it. And when I did, after many years, accept a collaborative case, I had asked the other attorney for some financial records. He said to me, well, Linda, I'm not going to give those to you. And I said, why not? And his answer was, well, you know, we'll give it to a financial neutral. Well, we didn't have a financial neutral. I didn't think it was necessary to hire one. I know how to deal with financial records. But that's kind of where it went. That was the last collaborative case I did. It's the last one I will do. So while in theory, I think it probably has some good ideas associated with it in terms of how it would be beneficial to people. In practice, I personally don't see it that way. So that's not something that I recommend. If by whatever method, and there can be a combination of methods here, there is the ability to reach an agreement. Any agreement should be written down. And unless you are an experienced family law attorney, you are not qualified to do the writing. You want an attorney to draft the document for you to make sure that it says what it ought to say, contain language that it ought to contain so that you're protected. So even if you have the wherewithal to save some money by working things out yourself or by doing mediation, no matter what, somebody needs to go to an attorney to get it drafted, and then the person who didn't hire the attorney to draft it also needs to have separate counsel to review it from the perspective of, does this agreement cover what it ought to? Is it in your best interest? Remembering again that even if we go to mediation, it's not the mediator's job to look out for you or make sure that you've hit everything, because the mediator doesn't represent you. So my story in connection with this scenario was a case I had many years ago where the wife had formerly been, I think, a legal secretary, and she thought that she was qualified, they thought she was qualified, let me be more accurate, to draft a document that was an agreement. Many years later, parties divorced. This document became front and center for a huge battle between the parties. I can tell you my client spent about $90,000 on the subject matter. The wife, I'm sure, spent the same amount of money. And I'm absolutely certain that the decision that the judge made bore no relationship to what the parties intended when they executed their document. However, the document was ambiguous and it was capable of a lot of interpretation. So again, even if you can save money in other places, make sure you spend the money to have the agreement reviewed to make sure it does what it ought to do. Another agreement item I'm going to say to you is that when you go through the process of doing an agreement, and again, none of this is easy, make sure the agreement is a document to which you can refer in those instances where maybe the two of you aren't getting along as well as you are right now. So I've had many opportunities to review an agreement that says parties will equally share time with the children on the holidays. And I say, what does that mean? My idea of sharing time may well be different from my spouse's idea of sharing time. And if you take holiday situations, all the plans that go on, the family that comes in, etc., there's no better way to ruin a holiday than have a fight about when's the child getting picked up, when's the child getting delivered, when can I have dinner with my family, when are you coming back into town so that I can get on a plane and go somewhere else. It's horrible. So it's a lot of work, it's hard, but you want an agreement to answer questions for those opportunities when you have a dispute and you're just not getting along as well as you are now. So be precise. Now, if we talk about we're having an every other weekend schedule, when does the weekend start? Is it Friday after school? Is it Friday at 6? Is it Saturday morning at 10? When does it end? Is it Sunday night? Is it Monday morning return to school? Be precise. Days of the week, times of day. When we're talking about holidays, same thing. Be specific. When does it begin? When does it end so that we don't have these issues? If we have a summer schedule that is different from the quote-unquote regular schedule, when does the summer schedule start? You know, if we get out of school on a Thursday, does the week off start on Thursday or does it start on a Monday? It doesn't matter what it is. You just have to be precise about what it is. And I don't think I mentioned when I talk about access schedules to also make sure that you provide for summer vacation. You know, if we have a schedule that involves a lot of midweek access, one could read that and say, well, wait a minute, how do I get a block of time to go away for a week? You also want to consider when decisions are made about vacations so that, you know, things like camps, etc., and summer daycare can be addressed. So when you do the work of doing an agreement, make sure you do the work. Personal property is another item. I've seen many agreements that say we will equally divide the personal property in the house. And then out on the front lawn, you've got each party with an end of the big screen TV. Well, I want this. There's no resolution there. So sometimes people go to the house and they make a list. Sometimes they alternate making choices. But an agreement to agree is not an agreement at all. So if you're going to do the work, make sure you do the work and create a document where when you go to it with a question, you can get an answer. All right, that was agreement. The other scenario, and this is the harder one, is litigation. So if there's an inability to agree, the only other way to resolve the issues that we've talked about is by litigation. And when I talk about litigation, I'm talking about going to court, filing with the court, getting the system involved. So once we file for divorce, the process in Howard County anyway is that a scheduling conference is scheduled. And at a scheduling conference, thank you, you have a meeting with someone in the court system, and we walk out with what's called a scheduling order. And what that order does is it has deadlines. Here's dates by which discovery must be done. Here's dates by which certain hearings have to occur. Here's dates by which experts have to be identified. So once you file, you have time limits. You have deadlines. You must start spending money in order to meet all these deadlines. One of the things that gets set at a scheduling conference is what's called a pendente lite hearing. And that's a hearing at which the court has the authority to make interim, temporary decisions on issues related to custody, access, child support, use and possession of the family home, and alimony. So you can imagine the scenario where our grounds for divorce might be a one-year separation, desertion, constructive desertion, and we have to wait for a year before we're eligible for the final divorce. Well, there's a thing called a limited divorce that can be pursued prior to that 1 year that enables us to get into court, to get some interim relief from the court, and that's by way of what's called a pendente lite hearing. When we have one of those hearings, they occur in front of a family magistrate. A magistrate is not a judge, although the hearing appears like it operates just like you're in front of a judge. But at the end of that hearing, a magistrate makes recommendations. They're put into writing. If someone is unhappy enough with the recommendations, then they have the right to file what's called exceptions, which is an opportunity to appear in front of a judge to basically allege that the magistrate committed error during the pendente lite hearing. These are just processes that you are likely to encounter if you are involved in the court system. And as you listen to me, as you look at this, you should be seeing dollar signs, because everything that's involved here obviously involves your counsel, involves the expenditure of time and the expenditure of money. But the court system really does not want to hear your case. It wants you to resolve it. So when we go to a scheduling conference, one of the things that the court will schedule is a settlement conference. So that is an opportunity to meet with a retired judge prior to trial to see if that judge can help you settle your case. If we have a contested custody issue, then the court is also going to order you to go to mediation. Again, the system's going to try to spit you out so it doesn't have to resolve your case. But if all that doesn't work, if mediation doesn't work, if the settlement conference doesn't work, then what's going to happen is when that settlement conference concludes, we'll go to the clerk's office, we'll get a trial date, and we'll go to trial. And what that means then is the third person who doesn't know you is going to make major decisions affecting your life that you're going to have to live with. So when I sort of put this all into context and we talk about agreement versus litigation, what other major issues in your life do you put in the hands of a third person who doesn't know you, who hears you for several hours or for a day or two in a courtroom, and then make these huge decisions about where your children are going to live, when are you going to see them, are we going to sell your home? And so clearly, if you have the wherewithal to maintain control over these decisions, it's better, obviously, for the gravity of the situation. It's more cost-effective to do it that way. You have some possibility of preservation of a relationship, because I will tell you that, you know, things aren't good, obviously, to lead people into the divorce arena. And whatever's not good, it will get worse if we go into litigation. Things are amplified. It's an adversarial process. So if you do have the wherewithal to resolve things, so much the better. If the circumstances are that you can do things by way of agreement, like I say, in terms of choosing a mediator, you're going to want somebody who's got a lot of experience. There's a lot of mediators out there. Every one of them is different. Some are more proactive than others. And how do you make a choice? Well, one of the ways you make a choice is you do what you're doing this morning, and that is, now you know something about me. You know a little bit about how I operate. Maybe you are aware of other individuals who've gone through mediation. You talk to them about what their experience has been. I'll call myself the dinosaur that I am and say, you don't want to look in the phone book. I don't know if anybody uses the phone book anymore. But you want some indication that you're making a good choice. Again, not everybody can do things by way of agreement. If you have to litigate, again, you want somebody who is experienced, who knows what they're doing, who's been around, who has a good reputation for integrity, for dealing in reasonable expectations. And again, how do you do that? Well, you've learned something about me today. You can ask other individuals who've perhaps been involved. Meet an attorney and have a consultation, you know, because whoever it is who's representing you has to be an individual that you trust, because they know how to do something that you don't know how to do. So I thank you for your attention this morning. If I can be of assistance to you as a mediator, as an arbitrator, as a litigator, for a consultation, my contact information is on this page. Feel free to email me, and I'll be happy to help you if I can. So before we conclude, I will ask, are there any questions that anyone has?